Hi, my name is Dr. Benson and I'm a Senior Legal Counsel here at the Commission, and I'm going to talk to you today about credit fees and what's new in the world of credit fees. The first thing that's new is the flagship case about the interpretation of the fees provisions, Sports Zone and MTF. The decision was released by the Supreme Court in May of this year. I'm going to give you some background about what that case was about, in case you don't already know, and I'm going to highlight some of the principles that came out of it. I'm going to talk to you about some of the amendments of the CCCF that came into force in June last year. They included the introduction of the lender responsibility principles, and I'll touch on how the Commission thinks the lender responsibilities and the responsible lending code affect how you go about calculating your fees. There have also been some changes to the fee provisions, and I'll outline what those changes are. As Anna mentioned, the Commission's draft fee guidelines were released for consultation earlier this month, and I'll highlight some of the key points that we're making in those guidelines. I'm also going to talk to you about some of the other fee cases that the Commission has taken recently. Some of those cases are currently before the court, so I'll be a bit restricted about what I can say about some of them. Then we're going to have questions. Hopefully we'll get about 15 minutes for those running into time. First of all, however, I'm going to remind you about what the fee provisions are and what they say. So, the fee provisions are set out in subpart 6 of the CCCF. The primary section is section 41, and it's a general prohibition on unreasonable fees in consumer credit contracts. And I note that the prohibition is on providing for unreasonable fees, not necessarily charging them. A credit fee is defined in section 5 of the Act, and it's not necessarily any fee that's charged under a consumer credit contract. Particularly, it does not include fees for optional services, interest charges, government charges, duties, taxes or levies, and third-party fees where the third party is not associated with the lender. There are particular sections of the Act that deal with particular types of fees and give guidance about how the court should make an assessment about whether a fee is reasonable. So, establishment fees are dealt with under section 42. Establishment fees are always establishment fees, and they are fees that relate to the costs that you incur in connection with the application for credit, processing and considering that application, documenting the contract and advancing the credit. The court must consider whether the amount of the fee exceeds your costs in performing those tasks. There's also a section that deals specifically with prepayment fees, and a prepayment fee is a fee that's charged on full or part prepayment of a credit contract where the interest rate is fixed for an agreed period and where you have suffered loss as a result of a change of interest rates. In considering whether or not a prepayment fee is unreasonable, the court will consider whether or not the fee exceeds your reasonable loss estimate of loss arising from the prepayment. There are also sections that deal with credit fees other than establishment or prepayment fees and default fees. There's finally a section that deals with third-party fees, and generally the rule there is that you can't clip the ticket, so you have to pass those fees on to the borrower at the amount that they were charged to you. So, Sports Zone and MTF. What is the case about? The MTF provided motor vehicle finance through dealers such as Sports Zone. Both MTF and Sports Zone charged fees to the borrower in connection with the consumer credit contract. MTF, when it set its fees, generally took all of its operating costs and assigned them to 3 fee types and charged them to the borrower. The fee types were establishment, account maintenance and default. For example, it sought to recover directors' fees and travel costs its legal fees and cost of annual financial audits and its establishment fee, and it sought to recover the cost of bad debts and its default fees. The Commission's view was that not all of these costs, those costs particularly, were not recoverable in credit fees. We took civil proceedings in the High Court alleging that the fees were unreasonable. We thought that the case was really important. It was critical to the overall scheme of the Act. Our view was that, and is, that the fee provisions were intended to restrict the amount of fees that could be charged, but at the same time allow lenders to recover their costs and profits through an annual interest rate, and doing this would allow products to be compared by borrowers on the basis of the annual interest rate. In our view, allowing creditors to recover all of their costs and fees disguised the true cost of the transaction to the borrower. If MTF's approach in setting fees was permitted, it would mean that the annual interest rate was not a reliable indicator of the cost of the transaction to the borrower. So the High Court agreed with the Commission's interpretation and found that lenders could recover costs that were closely related to the matter giving rise to the fee. MTF appealed to the Court of Appeal, and the Court of Appeal upheld the High Court's decision. It's taken about 10 years to get that litigation finally resolved. It arose from a complaint that the Commission received in 2006, and the Commission filed its first statement of claim in 2009. So as I mentioned, the Commission succeeded in the High Court, Court of Appeal, and ultimately in the Supreme Court. So I think we can now say that the fees provisions, the interpretation of the fees provisions, have been now thoroughly stress tested. Although there are still some matters that the Court has not considered, the general approach to the fee provisions is now set. Some of the key points that came out of that judgment were that comparability and consumer protection are the primary objectives of the fee provisions. The Court accepted and noted that interest rates are not capped, but said that the fee provisions of the Act are a real restriction on fees. The Court said that most of a lender's costs should be recovered in the interest rate, and that allows borrowers to compare products on an annual interest rate. Lenders can charge fees to recover specific costs relating to particular transactions. The second key point is that costs and losses are key. So the defendants in Sports Zone said that the Court could consider non-cost-based factors that they said meant their fees were not unreasonable. So they said that the Court could take a broad common sense approach to determining reasonableness, and that fees were not out of line with other fees charged in the industry. They argued that the Court could take into account all other factors that had a bearing on reasonableness. The Supreme Court rejected that argument. They said that while courts were not only required to consider costs, costs were not necessarily the only relevant consideration, the Court did say that Parliament did not contemplate the possibility that a court would be able to conclude that factors other than cost would outweigh cost in the determination of the reasonableness of fees. In terms of comparing fees, a comparison of fees charged by other lenders, the Supreme Court said that this didn't take into account the relationship between costs, your costs and your fees, and that you couldn't assume that a competitor's practices were reasonable. Lenders must apply a transaction-specific approach to costs. So the High Court and Court of Appeal said that lenders could recover costs where they were sufficiently close and relevant to the matter giving rise to the fee, so that it could be said that the cost was incurred in connection with it. The Supreme Court agreed and further explained this by saying that lenders should only recover their transaction-specific costs. There was some discussion in the judgment about fixed and variable costs, but the Court said ultimately that those descriptions were not particularly helpful. The Court was clear that not all costs are transaction specific, and that general overheads should not be recovered. the Supreme Court said that many costs incurred by a credit provider will not be referable to particular credit transactions and they will therefore have to be recovered in the interest rate. The court also indicated that there may be some fees that should not be charged at all, that were inherently unreasonable. They said, on the face of it, the charging of a fee that could not be justified at all would fall foul of Section 41. In the present case, the Commission did not argue that any of the fees charged by Sports Zone or MTF were unreasonable per se. Its argument was aimed solely at the level of fees, and for this reason we do not express a view as to whether the existence of any of the fees was reasonable in itself. The decision also makes it clear that costs themselves have to be reasonable, that is, the level of costs. So those are important principles to take into account when you're setting fees. The next big thing is the lender responsibilities. In terms of what you need to do to comply with the lender responsibilities in setting your fees, the first thing you need to do is make sure that your fees are reasonable. The lender responsibility principles require you to comply with all of your legal obligations. So if you provide for unreasonable fees, not only will you breach Section 41, but you might breach the lender responsibility principles. There's also an overarching principle that you must act with the care, diligence and skill of a responsible lender before entering into an agreement to provide credit or finance. In our view, this involves acting with care, diligence and skill in setting your fee, in reviewing your fees and in keeping records. So what do you need to do in setting your fees? Well, there's guidance set out in the Responsible Lending Code. There's now some guidance in Sports Zone, and that is all reflected in our draft credit fee guidelines. It will involve you gauging your costs, either using your actual costs per transaction or reasonably estimated costs for an anticipated number of transactions. We do think that it is important that you review your fees regularly to check your assumptions, to check the assumptions that you made about your costs and the number of transactions. You need to do this when you become aware of material changes to your costs or the number of transactions, and we recommend that you review your fees annually. When you are preparing your annual report, seems like a good time to do it. It's important to keep good records about your processes in setting your fees, and there are two good reasons to do this. Firstly, we think it's consistent with your obligations under the lender responsibility principles, and record keeping is discussed in the code. And secondly, there is a risk that a court might find that your fees are unreasonable if you haven't kept proper records. The High Court in Sports Zone said that the Commission has to show that the fee is unreasonable, but once we've established a primary case, the lender is likely to have to bring evidence to disprove the allegation. We had a recent case, which I'll talk about in a bit, called 2050 Club Limited, where the defendant provided no evidence about its costs or how it had set its fees, and the court accepted the Commission's case that the fees were unreasonable. I'll touch briefly on the changes to the fee provisions. And I'll only do it briefly because I think in our view the changes serve to clarify rather than to change the law. Technically the changes only apply to contracts entered into from 6 June last year, and there are three main changes. There's been a change to the definition of credit fee, so that fees that are charged by a third party that are associated with the lender will be credit fees and will be subject to the reasonableness provisions. The Act defines what is meant by associated, and it's generally associated because of ownership when we're talking about a company, but there's also a test about direct and indirect control, so that's just something to bear in mind. The section relating to prepayment fees has changed, and it makes it clear that you can't charge a repayment fee to recover your reasonable estimate of loss for variable interest rate loans. And as I mentioned before, previously the test for default fees and credit fees other than establishment and prepayment were lumped together. That's changed and they've now been separated. We don't think that has any particular effect, but it does make it clear that losses should be taken into account when setting default fees, but that's not relevant to credit fees other than establishment and prepayment. So our draft fee guidelines. So what's the story? They're in draft. We would, they take into account sports zone and other cases that we've currently got before the courts. They're available on our website, and I think we've got some copies here. Submissions are due on the 25th of October, and they can be emailed to the address there or posted to us. And I think there are details in the draft guidelines about that. As Anna said, we would really encourage you to read them and make submissions. You don't have to submit on everything, but if there's anything you'd like to say, this is your chance. They don't have to be lengthy submissions. If you have specific concerns or issues that you're looking for specific guidance on, please let us know. The guidelines will be considered by a range of people before they're finalised. What are the important bits? We're making it clear in the guidelines that we don't think that lenders can profit from fees, and that the lenders should only be recovering transaction-specific costs. So we're making the point that lenders can't bundle all of their costs and charge them to fees. They must relate to costs incurred in relation to particular transactions. We're reflecting the guidance in the sports zone that fees can be inherently unreasonable, and they must relate to a cost that the borrower should properly compensate the lender for. We use an example in the guidelines about a lender who purchased a loan book and sent all the borrowers a welcome letter and charged them $15 for doing that. In our view, that might be an example of an inherently unreasonable fee. We're reminding everyone that fees have got to be disclosed, and they should also be accurately described. You shouldn't be misleading consumers about what a fee is for. In terms of benchmarking your fees, we say it's not good enough to set your fee at the level of your competitors because the Act requires a consideration of your costs, and there is no guarantee that your competitors' fees are reasonable. However, if you are looking at your competitors' fees and you find that you're higher, this might be a red flag. So we suggest that in those circumstances, you make extra sure that your fees match your reasonable costs. Again, we make the point that you need to review your fees regularly because fees can only recover transaction-specific costs. It's not a case of set and forget. If you're estimating costs or estimating the number of transactions, you need to make sure that you have a regular process for checking that your assumptions are correct. We make the point that in default fees, you can't include an amount that is designed to deter borrowers from defaulting. And that's because default fees have to reflect the costs you incur as the result of a default. We also deal with fees for optional services, and the guidelines make it clear that these fees, that fees for services that are part of the product are not fees for optional services. They are credit fees and they will need to be reasonable. In order to be a fee for an optional service, it has to be genuinely optional. So, for example, for credit-related insurance, if 100% of your borrowers purchase it, we're inclined to think it's compulsory. We reflect an expectation that lenders will use a cost accounting approach when setting their fees, and that's been endorsed by the courts. The guidelines also set out the types of costs that might be able to be included in fees, and that those lists are drawn from the sports zone decision. So these are the cases of interest that we currently have before the court. The first one was our prosecution of 2050 Club. So we laid criminal charges against 2050 Club in 2014 for a number of contraventions of the Fair Trading Act and CCCF. Some of the charges related to the company's fees. 2050 was a payday lender, and it generally entered into loans of between $20 and $50. The amounts were due for repayment within 7 days or the borrower's next payday. The company didn't charge interest, but instead charged a marketing cohort of 50% of the amount borrowed. The Commission considered that this was a credit fee and sought information from the company about its costs in setting up the loans. The company failed to provide that information voluntarily and also failed to comply with a statutory notice. The Commission obtained some limited costs information as a result of a search warrant. The Commission took the approach that where the fee was more than $50, it was likely to be unreasonable. In our view, that was a very generous approach, and the evidence that we had about costs suggested that a much lower figure would be justified. However, the court accepted our argument and convicted 2050 Club under Section 41 for charging unreasonable fees. We've also currently got cases against Acute Finance, Cash to You and Harmony. Those cases are currently before the court, and I can't say too much. In the Acute Finance case, we're alleging that the company has charged fees for a repayment waiver that has exceeded its reasonable costs. And in the Cash to You case, we allege that the company's fees charge for costs that it hasn't incurred. And as you might be aware, we are taking proceedings in the High Court in Auckland to determine whether Harmony's platform fee is a credit fee.